You're watching the legal breakdown. So, Glenn, the question I've gotten more than any other question this week: could Trump already be disqualified from running for office under the 14th Amendment to the Constitution? Professor Lawrence Tribe and Judge Luddig both co wrote a piece in The Atlantic arguing exactly this point. So, from a prosecutorial perspective, do you agree that there are already grounds to disqualify Trump from holding office?
Let me not bury the lead. The answer is yes. And frankly, I got justice goosebumps watching Judge Luddig, who is kind of a lion of a constitutional scholar on the conservative side, on the right, and Professor Lawrence Tribe, who is a lion and a constitutional scholar on the left. When I watched those two men come together, both on TV and in a written op-ed, and say that we have both studied this issue, as have other constitutional scholars, and we have concluded that the 14th Amendment, Section 3, is self-authenticating, and Donald Trump is disqualified from being placed on the ballot by secretaries of state. That, I think, is a powerful constitutional opinion. And the way I'm looking at this now, Brian, is this is the kind of disqualification that, frankly, is no different than being 34 years old or not being a natural-born citizen. These are constitutional disqualifications. And what is the consequence of having a constitutional disqualification? A secretary of state may not constitutionally put your name on a ballot as a candidate for the presidency. So hold on tight, because this issue is just getting warmed up.
Now, how would this process actually play out? What would this look like, practically speaking?
Yeah, the good news is we've all been struggling for, okay, what is the mechanism? What is the vehicle, right? What is the proceeding that allows people to conclude, yep, Donald Trump is disqualified because he participated in an insurrection or gave aid and comfort to the insurrection. And he did both of those things and continues to do both of those things. Because when you read Section 3 of the 14th Amendment, it doesn't say anything about, well, by the way, here's the process. Here are the steps that the country needs to go through in order to disqualify an insurrectionist. But, you know, Professor Tribe and Judge Luddig really did kind of set out precisely how the procedure will play out. And it's a thing of beauty. So here's what they say. They say, you will have a Secretary of State. Let's just call it what it is. You're going to have a Secretary of State in a blue state, right? A state dominated by the Democrats, who will say, okay, there are constitutional authorities who tell me that I will be acting unconstitutionally if I put Donald Trump's name on the ballot for the presidency in my state election, and I'm not going to do that. So what will happen? That will inspire a lawsuit brought against that Secretary of State to challenge that decision, and then that will work its way through the courts. Let's go over to a red state. You're going to have a Secretary of State from the red state say, I don't care what these people are telling me, that it might be unconstitutional if I put Donald Trump's name on the ballot in my state, so I'm going to do it. That will inspire a lawsuit, and those lawsuits will work their way through the courts. I have a feeling, Brian, based on everything I've read thus far, and I have a lot more to read, I do not pretend to be the constitutional scholar that Lawrence Tribe or Judge Luddig are, but I think it's a winning argument. And I think once these issues get before judges, they're going to hold an evidentiary hearing, and they're going to conclude, and I believe the burden of proof will be a preponderance of the evidence. That's important, because it's a much lower burden of proof than if we were going to rely on criminal prosecutions to prove Donald Trump is an insurrectionist. That's the mother of all burdens of proof, beyond a reasonable doubt. So I have a feeling the courts will continue to hold, just like they have held in the election challenge cases, and the Supreme Court has held. They haven't given any play to any of Donald Trump's BS claims in the election challenge arena. And you're going to have judges decide that Donald Trump is disqualified and his name may not be placed on the ballot. Now, we both know where that issue is ultimately going to end up and be decided. It's at the Supreme Court.
Well, to that exact point, on this idea that it'll be decided in the Supreme Court, why wouldn't this be a state case? Because the power to run elections is specifically and exclusively a state's issue. So why wouldn't it stay in California, for example, if the case is brought about in California and work its way through up to the California Supreme Court? Why does it ultimately end at the United States Supreme Court?
Yeah, so first and foremost, you're right. These are state matters, right? The states have wide berth to run their own elections. So it will work its way through state courts up to and including, state Supreme Courts, but it will also then hop into the federal system. The reason is because it really does also implicate federal constitutional matters. So one way or another, even though they will work their way through the state court systems, it's not all that unusual for cases to sort of jump collaterally from the states to the feds if there is some jurisdiction that the feds believe they can exercise over that particular state dispute. That's the case here. This will end up at the Supreme Court.
For those of us who believe that Donald Trump did violate the 14th Amendment to the Constitution, what is the biggest obstacle to this playing out, to this bearing itself out?
The biggest obstacle is the Supreme Court. Of course, that's an unknown. What will the Supreme Court ultimately do when they, are the last stop for deciding this issue? And here's my take on that. I don't have a lot of confidence in the Supreme Court these days. I don't have a lot of confidence in the integrity of a half a dozen justices on the Supreme Court these days. But there is one thing that I am supremely confident about. The Supreme Court loves its power and loves its status as the supreme governmental body, the last stop that gets to render an opinion on what is constitutional and what is not constitutional. And I think that will be a primary motivator when they are tackling this issue. They will not put an aspiring dictator like Donald Trump back in the White House. Why? Because a dictator has absolutely no need for a Supreme Court. So they would actually be ruling against their own supreme status, their own power, and their own authority if they ruled in a way that allowed Donald Trump, an acknowledged wannabe dictator. He's the one who said he would cancel the Constitution, remember. They will not facilitate him by rendering a legal opinion that puts him back or has the potential to put him back in the White House. I know that's a very bleak view. That's not how Supreme Court justices are supposed to undertake decision making. But I'm sorry, I don't have a lot of faith and confidence in the court these days, and they will continue to be strong in the election arena, but not necessarily because they will strictly be concerned with how to best interpret the Constitution. It's also self-interest.
Regardless of the merits of this whole effort, of which there are many, and that's pointed out again, by people across the political spectrum, from Professor Tribe all the way to Judge Ludwig, it's still a more difficult avenue than, for example, having included insurrection as a charge in one of these federal cases. So why not, if you're Jack Smith, why not have included insurrection as a charge in the DC case, for example?
Another great question. I've scratched my head and asked myself, why didn't Jack Smith charge Donald Trump?
Is there any downside to having included it? I mean, granted, it may not be such a home run as the other cases, which may be more black and white, more obvious in terms of his culpability. But is there any downside to having just included an insurrection charge there?
There is. So I sometimes had to prosecute a single defendant or investigate and decide whether to prosecute a single defendant for example, 5 murders. I might have believed that he committed all 5 murders. I might have even believed that I had a pretty good shot at proving beyond a reasonable doubt he'd committed all 5 murders, but I didn't want to play against myself by bringing cases that were either a little weaker on the evidence or that maybe had some novel legal challenges that could be leveled by the defense. I might only charge the 2 strongest murders or the 3 strongest murders. Jack Smith, I believe, wanted to sidestep the First Amendment challenges that would have been robust challenges to inciting an insurrection, courtesy of, for example, Donald Trump's January 6th speech on the ellipse. And what you do when you lump that kind of a case, that kind of a charge in with charges that are considerably stronger and have absolutely no potential First Amendment defense attached to them, sometimes you're playing against yourself in the eyes of the jury. You don't want to dilute your case on the strong charges, and you don't want to give the jurors anything to puzzle over, to disagree about, because that can not only result in an acquittal, a not guilty verdict with respect to those more challenging charges, it can infect the rest of the case and the other charges. So, and here's the other downside as I see it. I think Jack Smith may have been 3 steps ahead of all of us by declining to bring the insurrection charge because he already knew precisely what Judge Luttig and Lawrence Tribe knew, which is that there is a vehicle for Donald Trump to be held accountable for the insurrection by being disqualified from running for president again or holding federal office again through this civil process. And let's assume that Jack Smith brought an insurrection charge. And even though Donald Trump was convicted on the other charges, he was found not guilty on the insurrection charge because of the First Amendment challenges. Maybe it gave one or more jurors a little bit of doubt. So they cut Donald Trump some slack on that. That not guilty charge on an insurrection crime might infect the ability to go into civil court and litigate whether Donald Trump was responsible for the insurrection. Now, let me quickly add that a not guilty verdict in a criminal trial is not admissible evidence in a civil trial, but boy, is it atmospheric evidence in the court of public opinion that could end up making the civil challenge much more difficult. I know all of this is a mouthful, but this is how I see the interplay and how I see some of the arguments in favor of Jack Smith's decision to decline to bring the insurrection charge.
Now, if this effort to invoke the 14th Amendment to the Constitution does eventually play out, when will we first see it? When will we first know that that's being attempted by some, most likely Democratic Secretary of State?
It's a good question, and I don't know precisely the timing or the deadlines involved of the Secretary of State certifying the names of the candidates that will go on the state ballot. I suspect that will be, sometime during the nomination process. I just don't know precisely when. But let's remember, we've already seen civil suits brought and litigated against alleged insurrectionists, albeit them in Congress. There's an organization called Free Speech for People, a nonprofit. They have been filing suits against members of Congress who participated in the insurrection, and they tried an entire civil case to see whether a judge would rule that Marjorie Taylor Greene participated in the insurrection such that she should be disqualified. Interestingly, that case made its way through the system, and the judge ultimately concluded there wasn't quite enough evidence. You may remember, this is the one where Marjorie Taylor Greene was placed under oath and testified that she couldn't even recall her middle name, never mind what she was doing on and around January 6th. I'm taking liberties, but it was pretty pathetic that she couldn't recall anything that might have incriminated her or been damaging evidence to her. But these cases have been working their way through the system, albeit against members of Congress. So It's not that it's unprecedented that these suits can be brought and can successfully be litigated. We just have to get to a point where there's enough evidence, and I think there's enough evidence to prove in a civil case that Donald Trump absolutely incited, engaged in, assisted, or gave aid and comfort to the insurrection.
Well, that seems like the perfect place to leave off. So obviously, we'll watch this effort bear itself out as we move closer and closer to the election. If you want to stay on top of this stuff as it continues to bear itself out, make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.